Hi everyone, I'm maritime personal injury attorney David Saltaformaggio. This video is part of my Seamen's Rights and Remedies video series, which is designed to educate you as seamen on your rights and remedies in the event of an injury. I previously discussed the two-part test that must be met to qualify as a seaman. Under certain circumstances, marine and energy employers and vessel owners and operators and their insurers will vigorously fight whether you are a seaman, because if they can show you're not a seaman, then they'll not owe you the special rights and remedies that protect seamen. An important issue that arises often and is generally the focal point of all seaman status disputes is whether the maritime worker's connection to the vessel was both substantial in duration and nature. The rule of thumb in answering that question is that a maritime worker who spends less than 30% of his time in the service of a vessel in navigation likely will not qualify as a seaman. To give you an idea of how this rule is implemented, a port captain or repairman who spends a majority of his time inspecting, repairing, or maintaining his employer's fleet of vessels that is moored at its shoreside facility will probably be considered a seaman. On the other hand, a shoreside employee in the safety department, for example, who sparingly works aboard his employer's vessels, likely will not qualify as a seaman. In my next video, the Seamen's Rights and Remedies video series, I'll discuss more practical, everyday examples of whether or not maritime workers qualify as seamen. Thank you, and I look forward to speaking with you next time.